Thank you for joining me, Advocate. Let's start with just some background to the amendment bill that was introduced last week in Parliament. It all stems from that court case last year at the Constitutional Court in which this particular section of the Criminal Procedure Act was found to be constitutionally invalid. What was found to be the problem, the lacuna that the Constitutional Court spoke of, that is now being fixed by this new bill?
Thank you for having me, Tulasizwe. So, as you mentioned, the judgment was trying to cure two main things. The starting point was that actually the Criminal Procedure Act did not have protection for victims. So it had for child offenders, it had for child witnesses. But we saw when we were representing Zephany Ness that the threat of her turning 18 and media houses wanting to reveal her details, actually when we looked at the law, was that the Criminal Procedure Act had not specifically made it clear that child victims also are protected in terms of their identity. It was read as if the minute they become witnesses, that's when they will enjoy the protection. So the two things that the law intends to cure is making it very clear that people who are child victims, and the law reads that people who are allegedly to have had offense committed against them. So it's actually explained, it's broadly, nicely worded in the bill that's now going to be passed. And then secondly, as you said, the protection, the Act did not say the protection ends when you turn 18. However, it was being interpreted to mean that by particularly media houses, which is what we saw in the Zephany Ness case, where they were waiting for her to turn 18 so they could reveal her real identity, which at that time you still had the criminal case against the woman who had kidnapped her, the mom who raised her but had kidnapped her, was still pending, and she needed continued protection. So that is the next, the second thing is that the law now makes it clear that as a child victim, child offender, child witness, you enjoy protection, and that protection doesn't automatically lapse when you turn 18. The law now makes it very clear what will be the process for somebody to apply to have a child victim, child witness, or child offender's name be published. They have to bring an application. And even you as a child offender, child victim, or child witness, you can apply to actually have your name publicized, which is what Zephany did in the end when she applied to have the protection lifted so she could publish the book that tells the story of her life. So those are the main two things that the current provisions do now.
So in terms of this protection of the identity, to after the proceedings have concluded in the court and even the child victim witness offender has turned over 18, why is that important? Beyond the circumstances that were unique to the Zephany Ness issue, what is the impact of having that identity revealed at a particular point that, the law is trying to mitigate against?
Yes. So, I mean, the first thing is that when we're dealing particularly with child offenders, under the Child Justice Act, all their proceedings are also closed in that it's not open to the public. And the whole idea with child offenders is that you are hoping that they can rehabilitate. So there's a whole scheme about rehabilitating child offenders and giving them a second chance. But, when we argued before the Constitutional Court and before the High Court, we made the point that if you look at the rehabilitative purpose of the criminal justice system for child offenders, and then you don't extend that protection to when they turn 18 and above, you actually have negated the whole process of trying to rehabilitate them. Obviously, if they do then offend when they are adults, the law will deal with them as adults. But what we had seen, and actually prior to me even joining the Center for Child Law, my predecessor had represented children who had actually enjoyed protection beyond 18 and had rehabilitated themselves, have never committed offenses again in their life. So there is an issue about rehabilitating, not labeling children who committed offenses when they people who committed offenses when they were children and did not know any better in most circumstances. So that is where that protection comes in. And insofar as victims are concerned, one of the concerns that we saw was that they had people want to write stories about people. And I know you said beyond Zephany, but Zephany actually is an example. There was a person who was planning to publish a book about Zephany without Zephany's consent, without her input, and she was a victim, and the person intended to publish it without her agreeing to that. When she turned 18, the person was waiting for her to turn 18. And that shows that, then you as a victim might end up not having a say in relation to things that intimately affect your life and how you want to tell your story, because somebody else is choosing that they have enough information in the public about the victim that they can actually publicize whatever. And it's for the victim to then rehabilitate. And when they feel that they're in a position where they want people to know who they are and to tell the story about what was done to them and how they overcame that, it should be them who are able to elect for that.
Right.
And in the Constitutional Court judgment, actually, that is captured by the judgment of the court, particularly in relation to victims and how we should allow them space, and then they must choose. You can't have automatic provisions that say that now people can publish.
Absolutely. It's really about respecting the dignity of those people, even as they grow and become over the age of 18. Lastly, Advocate, an issue that arose a bit earlier on today, the postponement in the Tasneem van Wyk murder case by over a year. I mean, it's postponed to the 16th of May 2022. This is a child who was 8 years old, and the body was discovered in a stormwater drain outside Worcester. We are talking as it is Child Protection Week. You practice in the area of child law, and the rights and interests of the child are central to what you do. I mean, what's your thinking? I'll tell you what I think, because, I'm honest and open about it. I'm outraged. Over a year in terms of the postponement, I'm thinking about the family of this child and other people who have an interest in seeing justice, society as a whole, in seeing justice being done. A postponement of over a year for me is not good enough, but I don't know how you feel about it.
Well, that's why some of us don't like this idea of Child Protection Weeks being a week where people come and talk nicely about how they're protecting children's rights. Our systems are failing on a daily basis, and that will be my view. I will also not mince words about it. There needs to be an explanation by the National Prosecuting Authority, by SAPS, if they're still investigating. Explain to the family, explain to us, why is it that today you say that we can only come back next year, May? What is it that you need to do in that time? Because as you say, our justice system is failing, and we know violence against children and violence against women cases are piling up in our courts, and there needs to be an explanation. And we can't this week jubilate and say we have Child Protection Week when we have permanent systemic problems that we never get answers for. So that is my view.
All right, thank you for that. That's Advocate Karabo Oza. Thank you for weighing in on that issue as well, that I'm passionate about. I mean, that this one-year postponement really is unacceptable. And that's not just one case that we've highlighted. Can you imagine what's happening in the regional courts across the country as you navigate and you just check the court rolls? What are the other outrageous amounts of time that cases are being postponed for? Unacceptable.